Hey everybody, happy Friday. Got a nice turnout today. Guess a lot of people are interested in municipal services reimbursement, which is really good. And the good news is too that the rain has stopped, which is awesome, and hopefully summer can actually start now. And we get some days at the beach. Jeff Schiffman saying, no, no, the rain is coming back. Thanks, Jeff. You're raining on my parade. Killjoy. We wanted to get one day out of this as a nice sunny day, but okay. Jeff says no, no go. So anyway, hopefully you're wrong, Jeff. You're not often wrong, though. I will say Jeff is usually right. So, so nice to see everyone again. Fran McGovern, and the ground rules for First Fry with Fran. We know them already, but I have to say them every time. These webinars are provided for informational purposes only. General discussion. These webinars do not and cannot form an attorney-client relationship. The information exchange does not constitute legal advice. And to obtain legal advice, you must contact an attorney and directly explain your facts, your situation, what's going on, and get into a fee agreement with them. There we go. Okay. And you can imagine a dog that cute might give you a little bit of a hard time once in a while, but look at the face on that dog, huh? I am partial to pugs. I have a Brussels Griffin, which is like a furrier version of a pug. So similar face. It's nice to see. So the dog's name is Francie again, which is ironic because my name is Francis, and I spent my elementary school years getting beaten up because my name is Francis. But this is Francie the dog, very cute. Looks like St. Patrick's Day, but going for June on the calendar. And Francie is owned by June Gerling, who is a board member at the Woods at Laurel. So thanks so much, Jane, and very cute dog. And we'll just jump right into municipal services. Municipal Services Act. It's an old law. An old law. A lot of people don't realize that, but it is an old law. It was passed in about 1989, but then it was phased in from 1993 to 1997. And the reason it was done that way was um, municipal budgets had to kind of adjust to take into account the expenditures, right? Why do people want municipal services reimbursement or municipal services provided to them in associations? Because otherwise, you essentially have a double taxation situation, right? Because the people who live on public streets, non-association streets, they pay their taxes. The people who live in associations, they also pay their taxes. But wait a second, everybody. On the public streets, they're getting their trash picked up, they're getting their snow plowed, they're getting their street lighting paid for, they're getting all that stuff, and we're getting nothing. And in addition to that, for all of you in active adult communities, what else are you also doing? You are paying for the schools with no children in them. So that's why you've heard me refer to 55 and older communities sometimes, at least from governmental perspectives, as cash cows, right? And I have nothing against funding the schools. The schools should be properly funded, but active adult communities in particular felt the pain of the double taxation, right? Because they were just putting money out and getting nothing back. So Outcry and Rise Up said, hey, we need some help here, legislature. And after a whole lot of horse trading and so forth, they passed the Municipal Services Act, and it went into effect over a phased period from 1993 to 1997. It did not eliminate what we would call double taxation, right? It was a compromise. So some of the things that we did not get that we would like to get in the act, but we didn't. What about detention basins, Fran? How aren't there detention basins out there on public streets, and we have to pay, and they're really expensive, and they have to maintain them, and they get silted up, and on and on and on. The answer is no. Detention basins are not part of it. Many other things are not part of it. Storm drains under your private roads are not part of it. Water line laterals, things like that. I believe off the top of my head, I think standing water for fire hydrants is also not part of it. You don't get reimbursed for that. And it's usually a charge of the fire district. So it was a compromise solution, but it is helpful. The biggest shock to most board members is that the association doesn't get fully compensated for the association's cost of providing the three types of service. So it's basically snow removal, trash removal, and street lighting. But it's what the municipality would have spent to provide those services for the community. So associations, again, I like to use age-restricted communities because often they're the biggest. Oftentimes, this issue has the biggest impact on them. They will have a huge snow removal bill, and they'll say, Fran, we want this $250,000 back from the municipality. And the answer is no, you're not getting anything remotely close to $250,000 because the municipality is only obligated to reimburse you for what the township, for the municipality would have paid to provide the service. So many, again, active adult communities, they do far more than what a municipality would do in plowing the streets. So in a public street, the township runs the snowplow down the street and drives away, right? In an active adult community, you may have parking lots, you may have walkways, you may have stoops, you may have steps, you may have VitaPaths, we have jogging trails in some of these communities. None of that is going to be reimbursed at all, not at all, okay? And even the parts that are reimbursed, so again, the cost of running a snowplow down your streets, again, not your parking lots, your streets, is going to be reimbursed at what it would have cost the township, which is a lot less than, generally speaking, not always, generally speaking, than the township would have paid. The flip side of it, can the township provide the service if it wants to? Yes. Generally speaking, yes. I don't have a case at my fingertips right now on who makes that call, but I think generally the call is made by the township. Again, using active adult communities because it's the most extreme example. Most active adult communities would not ever want the municipality to provide the services, right? And the reason for that is generally you would get the same level of services that the public streets would be gotten. So you would not have primary roads, right? So the municipality would come out and plow your streets when it gets to it, right? It would also plow your streets in the same fashion that it plows public streets. So as you know, in many communities, the snowplow work, the snowplow vendor does all types of other things, right? So they'll not only plow the parking lot, but they'll have 10 guys or a crew that do handwork, clearing stuff between cars, giving access points on the walkways where there's a curb cut, things like that. The level of service, if you will, is far higher than what the municipality would have provided. So that's often a huge shock to the association when they're talking about municipal services reimbursement or municipal services provision, right? Because sometimes associations will look at it and say, well, wait a second, this reimbursement is so small, so de minimis compared to what we went out of pocket. Let's just have them do it. And just make sure you pause before any board makes that decision or talks to the township about doing that, because often the association's residents will not want that level of service, right? They either will not want that level of service, or even if they allow the municipality to do it, they don't want to then have the municipality plowing the cart paths and then the association having to go out and get their own separate snow removal vendor to handle the rest of the community. See what I'm saying? So even if they have the municipal snowplow guys or ladies plow the streets, you would then have to get another vendor to come in and do all the work that the public does not do. So snow removal, we talked about snow removal. So it's removal of snow, ice, and other obstructions from the roads and streets. Trash, solid waste, leaves, and recyclable material along the roads and streets. So some of these things get nuanced in terms of, and we wind up litigating some of them. You know, when it says along the roads and streets, what if we have dumpsters, right? So I don't know how many of you on the call, but what if we have dumpsters? Dumpsters become an issue. What about dumpster enclosures? What about the types of dumpster enclosures? What about whether we use garbage cans, but we don't have our residents put them on the street? Right? What about that? So some of these issues become very nuanced. Street lighting is a nuanced one as well. The act says that the municipality is only responsible for reimbursing the electrical cost of the street lighting. So not the maintenance of the street lighting poles, right? Not the maintenance of the bulbs, and not the maintenance, repair, replacement of the wiring, right? So you may have miles of wiring in your community. That's not reimbursable under the Municipal Services Act. Services versus reimbursement. We talked about that briefly already. Do you really want the municipality doing your snow removal, for example? That's usually the flashpoint. People generally do not. Um, Municipal services agreements. If you don't have a municipal service agreement in your community, you should work with your council to get one done, council and management, to get one done with the municipality. It's important to lay out the agreement, number one, so that you have expectations on both sides. but it is also required by the act itself. So, for example, we're in a bit of a municipal services dispute right now with one municipality, and the municipality, one of the defenses they're raising to our claims is, well, you don't have a written agreement. You have no municipal services agreement, so we don't have to pay anything. I think that is a total bogus argument. However, it's better to have that municipal services agreement up front. And again, the municipal services agreement, be careful, talk to your counsel, talk to your accountants even. Um, and depending how big your community is, you may want to hire separate experts. The reason for that, some municipalities will say, you know what, we're going to reimburse you for our snow removal cost as it would have been to plow your streets. So we have 1.1 miles of streets inside the community, and our trucks run about, 15 to 20 cents a mile per mile. So we'll happily give you 15 to 20 cents. But as you know, there's a person driving that truck. It's not the cost of the truck. It's not just the cost of the gasoline. It's not just the person's hourly rate driving the truck. There are a lot of other things that go into cost, especially if the person is a municipal employee. So there's pension issues, pension contributions, healthcare, all kind of details. So when you're talking about municipal services reimbursement, and the township wants to put a number out there, the devil is in the details. You have to figure out where that number is actually coming from. Again, if it's worthwhile to you in terms of cost benefit, because uh, just like boards, association boards, they have a limited budget, and if the association doesn't have to spend money, the association would prefer not to. If the municipality doesn't have to spend money, they would prefer not to, right? So, and that's why the title is municipal services. If you don't ask, you don't get, because we have many clients where we'll get a new association or an association who hasn't been involved and gotten us involved in municipal services, and they'll say, "Hey, Fran, it's so weird. The municipality doesn't give us any reimbursements." And I'll say stuff like, "So when was the last time you asked?" And you go, "We never asked." Well, they're not going to knock on your door generally and say, "Hey, can we give you some money?" No, no. If people start doing that, send them my way, right? Because I'd like people knocking on my door and say, "Hey, Frank, can I give you some money?" Generally, municipalities don't want to do this, and some municipalities are extremely aggressive in resisting payment of municipal services reimbursement. And we know that from litigating a number of cases ourselves. So, for example, 2 or 3 years ago, we had a case that we thought was a very good winner. I won't get into the details. We thought the association was right in their arguments. We litigated the case at the trial level. The association lost at the trial level. We thought that the association would have won on appeal. The association just didn't want to spend any more money on attorney fees, which was that's a valid business judgment by the board. You can make that call. But the municipality defended our claims against our claims very, very aggressively. So yeah, keep that in mind as well. One interesting thing when I have the line there, other stuff, there's language in the act that says nothing in this act shall prevent a municipality from providing additional services that primarily serve public purposes to residents or qualified private communities. So again, even if it's not one of the three services, trash, street laying, or snow removal, um, you can ask. It doesn't hurt to ask. So I have had an association. I don't remember the Emerald ash borer, right? When that got crazy, I had a community where they had emerald ash trees all around the community, and the community decided to take them down, and they were going to get a big ticket bill from their arborist to take them all down. They spoke to the town, and the town said, "Sure, we'll do it." And that was very nice of them, right? That's a beautiful thing. So it doesn't hurt to ask, because keep in mind, right? And sometimes association members forget this. You're all voters too. You pay lots in taxes. You're nice people. You help put these people in office, and oftentimes they may be willing to help out. We have seen this, like I said, in the emerald ash borer issue. We have had, I think this has backed off a little bit now. Historically, we have had some instances where um, municipalities were willing to pick up trash more frequently in terms of providing service than they would have on the public street. So this was an active adult community where people had issues with getting the large totes, if you will, from the garage area down to the street, and they had smaller totes and they didn't want to deal with the larger totes, and for a period of time, the municipality was willing to do 2 pickups a week instead of the 1 in the regular public street. So keep that in mind. It doesn't hurt to ask, right? You are constituents, you are voters in the town. They should be trying to work with you and getting things done. So as long as they provide, primarily public good services, you're okay. What about should we sue? Should we sue? What if the township just blows us off? The answer is, from a lawyer's standpoint, is yes. You have a right under the statute to either have the municipality provide the service or to get reimbursement for what it would have cost the municipality. The problem is that it is a real cost benefit analysis. Does it make sense to pay McGovern X dollars to pursue X dollars? We don't know, right? Does it make sense? And the problem is, depending on the size of your community, often it doesn't make sense from an attorney's fee standpoint, and or an engineering expert's standpoint, to expend the money to go against the municipality and try to win the case. So it's a tough decision from a cost benefit standpoint for the board. You really need to get a handle on your numbers. You need to really sit down with your attorneys, see how we can get a handle on the cost benefit analysis.
Hey, Fran,
What? Yeah.
just a
Yep.
thought on that. So
Yep.
keep in mind that there's generally speaking, a 6-year statute of limitations on how far back you can go to reclaim amounts owed to the association. So if one reason or another you weren't recovering anything from the town for 10 years, you would be able to go back, generally speaking, 6 years in that recovery.
Right. So, yeah, so Mike makes an interesting point. It's a good point, but it's a point that also is fraught with risk. And the reason I say that is, so what some association will do, they'll say, "Hey, Fran, this doesn't make sense. We'll keep trying, talk to the municipality, trying to work something out. Um, but we don't want to sue them right now. They only have blown us off for a year. We usually only get $5,000 in reimbursement. So it's just not worth it because we think it'll cost probably, 20, 30, 40, $50,000, depending on the facts, to sue." So they'll say, "So let's wait and see what happens. And then in year 6, as Mike said, we'll sue, because then we'll be suing for $30,000. And at least it gives us a little bit better deal in terms of a cost benefit analysis." The problem with that is, and it may be a valid strategy, but the problem with that is it's very, very, very fact sensitive. Very fact sensitive, because there is case law in New Jersey, and the one it's an unpublished decision at the appellate division, which is Wyckoff's Mill Condo Association versus Heightstown. And what happened there was, generally speaking, when you're going to sue a town based on an act of the governing body, you must sue within 45 days of the act taken by the governing body. Okay. And what happened in the Heightstown decision was, it wasn't like the example that Mike's giving, where the town just blew everyone off. Heightstown actually voted and passed a resolution that said, okay, I think it was Wyckoff's Mill, did I say? Yeah. Yeah, Wyckoff's Mill. "This is what we're voting to give you. This is our resolution. Here's your check," right? And, they got the check. The association got the check. We were not involved in this case, but the association got the check and kind of called up the township attorney, called up township administrator. "Hey, we can still work this out, can't we? Yes, no, we'll see. I don't know." And then ultimately they couldn't work it out. The association's attorney sent the check back to the township, to the municipality, and then ultimately the association sued the municipality. Um, the the municipality defended by saying, "This is not, we blew you off. Our governing body took an official act, voted on a resolution at an open meeting, sent you the check. Therefore, you were obligated to sue us within 45 days. You did not, so you're stuck with it." And they lost both at the trial level and the appellate division level on that. So keep in mind, although there is some truth in what Mike said, it is a very fact sensitive analysis. So there are associations, and some of our clients have chosen to do that, to wait and sue after the accrual of 1, 2, 3, 4, 5 years, 6 years even. But you have to be very cautious as to the really specific facts, because we wouldn't want to see anyone burned by waiting on that period of time. Um, by the way, also some people ask this question: what about street sweeping? There are towns will reimburse for street sweeping. There are towns that don't reimburse for street sweeping, but the case law that I'm aware of right now basically says the municipality is not obligated to reimburse for street sweeping. But and that may have changed. The case I have is a little bit older right now, but there are municipalities who do provide for or reimburse for street sweeping, basically under that last provision because it benefits the public. Um, what about during developer control? So case law has gone back and forth with issues over whether the association um, gets municipal services reimbursement during developer control, because many municipalities force developers into what's called development agreements that says, okay, you can build your community here, but we're going to make you sign a developer agreement that says, so long as the association's developer controls the association's board, has a majority of seats on the board, the developer will absorb, snow removal, trash costs, and street lighting costs, such that the municipality does not have to. That case was litigated back and forth, the trial courts, the appellate courts, and finally the New Jersey Supreme Court. And the New Jersey Supreme Court said, we're not super comfortable with this whole arrangement, but so long as the developer agreement is in place, and for so long as the developer is controlling the board, um, the developer agreement can be enforced, and the developer can be made to abide by that developer's agreement. We think it's a bad idea, generally speaking, but developers want to build, and New Jersey is a really tough place to build already with respect to planning board, zoning board, township committee, all those fun things, soil conservation districts. And the Supreme Court of New Jersey basically said that that can happen. Once, obviously, that the homeowners take control of the board, that's a different story, right? You can't lay it off on anyone else once you have homeowner control. So there's a couple things to be careful about in the municipal services thing. Like I said, the biggest issue when it comes down to lawsuits and whether we should sue and whether the municipality is being fair to us is cost benefit. Really important to do the cost benefit of the attorney fees versus the anticipated recovery. Okay. So that was fast. Wow, that's like the first time I did it in 30 minutes, I think in months and months and months. I don't see many questions, but let's check it out. Need to get to town to cover the cost of road repair replacement. Okay. Yeah, so Aldamato says, I think that's the first one. Arlene says, hello. Hi, Arlene. So Aldamato says, need to get to town to cover the cost of road repairs replacement in 55 and older communities. That's a good point, Al. And so this is the problem with that. There's actually a provision in the Municipal Services Act, I have a copy of it here, that says a municipality shall be required to accept for dedication for public use by a qualified private community any road or street within the community that conforms to municipal specifications for public roads and streets. So that sounds pretty clear. Like, hey, if our streets comply with what the township required when they planned this community and what they had on the site plans and all those other fun things that the township signed off on, sure sounds like that means the township should be compelled to accept ownership of our streets, which again, to Al's point, would imply obligation to maintain, repair, and replace. The problem that has happened so far in the case law that I've seen on that type of application is it has been virtually impossible to show that the roads or street within the community conform to municipal specifications for public roads and streets. And I haven't been involved in a case so far in 30 years where an association has compelled the municipality to take ownership of the streets. And that's a mixed bag, right? So that's a hot topic, and I'm sure part of the reason Al is highlighting it is what have we been talking about for the past 6, 7, 8, 9 months is reserve funding, right? And if you have a big community with a lot of streets that are requiring maintenance, repair, replacement, you got to fund those reserves for those streets, right? But if you were to dedicate them to the municipality, not so much, right? Not so much. You're taking them off your books, and even if the association's members were not so happy about how the streets were maintained by the municipality, they may be really happy when they don't have to reserve for them or maintain, repair, and replace them. So Al raises a good point, and there is actually a provision in the act that provides that if the streets conform to municipal regulations, they must take them. It has not been a successful argument in the courts yet. From a legislative standpoint, um, it's possible you could go back there. I'm not a huge fan of limiting legislation just to 55 and older communities. Um, but it's an idea. It's oddly, right? This is oddly. So, in terms of public policy, there's always this, right, kind of tension, if you will, between people with money, people who don't have money, people who are making money, people who are not making money but have assets. And I don't have research in front of me, but I think people would not be shocked to hear that oftentimes the larger number of people who don't have money are the younger people, right? So if you're 18 years old, 19 years old, 20 years old, whether you're smart, not so smart, lazy, not so lazy, you don't have much money, right? You don't have much money. That's why they're all living in their parents' basements, right? So there is this tension between people without money, people with money, and also age, right? Because again, the tendency, at least in my experience, has been, and I'm an old person now, so I can say this, is that vis-a-vis the young people, the 20-year-olds, the 55 older than 60-year-olds of us tend to have more money than the 18, 19, 20-year-olds. I don't have anybody living in my basement at the moment, thank God. But but the kids generally have less money. So the 55 and older legislation sometimes seems attractive on its face, but I think we should also think about for the non 55 and older age restricted communities, it would probably make sense for them. And that again comes from an equal protection argument, Al. And you and I think I've talked about the equal protection type issues there. Hey, we're paying our taxes. These people in the public streets get their services. In fact, the statute itself anticipated it. So if we're willing to turn them over to the municipality, shouldn't they take it? So from a policy standpoint, Al, I think you're going down the right road, and it's making it even more emphatic when we have these reserve funding laws. Irv says, you want to take it, Mike?
Sure. Irv says, regarding snow removal, can we request the town plow the streets? The HOA does the parking areas and private areas. What about salting? What about leaves? Take it.
So the answer is yes, yes, yes. Yes. So yes, sir. So right. So it would include salting, leaves, etc. So the township would be obliged to either do it or reimburse you. And you can split the baby and say, hey, municipality, you do the cart path, and we will do the rest. That's possible. It's just that it depends. Do you want to deal with that? Right? Because the odd thing would be there, right? And again, we do have a lot of age-restricted active adult communities um, on the webinar. Um, Many active adult communities have a priority list for snow removal, right? So the people who are getting dialysis, for example, may get their driveways plowed out first. The people who are on treatments for chemo or et cetera may get their driveways plowed out on a priority list. However, as you might imagine, Irv, it would be odd that the association's vendor came in at 6 o'clock in the morning and plowed out people's driveways. Awesome, Mrs. Jones, that's great. Go to your dialysis appointment. And the township doesn't come out and plow the streets until 11, right? And Mrs. Jones is stuck in the middle of the street trying to get to her dialysis appointment. She passes out over a candy bar on her steering wheel, God forbid, right? So it becomes an administratively very difficult thing because especially in many active adult communities we work with, we have a lot of residents who are dealing with some really critical health issues that they really have to get out and get to their appointments, whether it's dialysis or chemo or what have you, that they have to get out. So it gets a little funky if you have two vendors there and the public vendor, municipal vendor, is not plowing the streets. Um,
Yeah, and
Go ahead, Mike.
yeah, Lynette says basically the same thing. I believe it'd be difficult to obtain a vendor to only do parking lots, driveways, and sidewalks because, again, they need to drive through the community to get there. So you're going to be working with the township. If you waited around for the town, it could become a nightmare.
Yeah.
So yeah, even if you have public roadways, a lot of times the associations will just pay their private vendor to come in and do the service. And by the way, the next comment from Jeff makes a lot of sense. It's the comparison between a Rolls-Royce service from the association versus a Yugo, I don't even know what that is, service from the municipality.
You're showing your age, Mike. That was a fine, what, Eastern European car, right? Right, Jeff? Yeah. It was like a little box. Um, let's see. So Irv says a landscaper can do it. I understand the service ramification, but that's a decision of the HOA. So it is a cost benefit decision, Irv. It's just, you're probably going to get some significant pushback after the first snowstorm. They'll have a party, right? When they first look at your budget for 2026. They'll be like, "This is so awesome. We reduced our operating budget." But after the first snowstorm, they'll be wanting to lynch you. Um, just saying. So you got to be got to be careful. Nobody, Elon Musk is not coming in to rescue you with his billions. Let's see. Marcia, our township engineer, changed the reimbursement qualifying LED lighting. Okay. All right, that's interesting. It should still be based, Marcia, in my understanding of the act, on electricity usage. So if the township or if the association, for example, modified the lighting and you're using much less electricity, that's fantastic, but they're only going to give you the electricity, right? There are programs that, and I'm not speaking to them right now. There are grant programs, I believe, the new Green Deal agenda, if you will, where some governmental entities or nonprofit entities may subsidize replacement of old style bulbs for LED lighting. But they're still only going to reimburse you for the electricity charge. The other thing to keep in mind about street lighting is, and I'm just totally making this up, you only get what would have been given on the public streets. So if the standard for the municipality is we put in a street light every 200 feet, that's what you get. And if you're the association, you say, well, wait a second, we have street lights every 100 feet because we're in a wooded community and it's a little darker here and blah, blah, blah. They go, we don't care, dude. Every 200 feet, right? We'll give you the charges for every 200 feet. It's whatever the standard is in township. And we see this a lot in beautiful communities, especially age restricted communities, where they may have lots of lighting or they may have lesser lighting, but the lighting is different lighting, right? So it's like bollard styled lighting with a certain type of street light here and there and everywhere. It looks beautiful, but the township still is going to say, no, you get one every 200 feet, right? That's all they're going to give you. All right. So it's that shocks some. I should have mentioned that earlier. That shocks some board members like, Fran, what the heck? We're only getting like a quarter of the number of the street lights we have electricity charge reimbursement. And that's the story. You may have much more lighting or different type of style of lighting in your community. What are your thoughts on various community negotiating with a municipality as a group? So I'm fine with it. So Irv's point, I'll say that again. What are your thoughts on various communities negotiating with municipalities as groups? I think that's a really good idea. The only thing that we've seen, and again, that significant litigation that we mentioned before, the only um, caveat to that is in that litigation, a number of the communities in the township got together and negotiated an agreement. We believed, in the association I was working for at the time, believed that that agreement was weak and they could have gotten more and should have gotten more. And it kind of hurt, I would say it hurt our case a little bit too. So I guess be careful who you get in bed with is always something to think about when you're dealing with legal issues. It's great to have strength in numbers, but at the same time, you got to be careful who's cutting the deal because the League of Municipalities, everyone here of the League of Municipalities. So the League of Municipalities is like an industry group for municipalities in New Jersey, right? So just like we're talking about right now, and just like Irv is mentioning, so in the community association world, we have the Community Association Institute, we have IREM, Institute for Real Estate Management, we have various trade organizations as well, and we talk about these things, municipal reimbursement, et cetera. But you can imagine at the League of Municipalities annual conference, what do you think they're saying, right? How can we pay these communities less? Right. So it's good, I think, to strengthen numbers, but be careful where you end up with strength in numbers, because at the beginning of negotiations, most parties are like, this is awesome. We'll all band together and we'll hire one law firm and we're going to negotiate with the town, right? And the small communities are going to say, that's great. I'll put in $500 to fund legal, right? And as anyone who has litigated know, $500 is burned through in like 2 seconds, right? So, and then what happens is the smaller communities may fall by the wayside, and the larger communities may wind up carrying the burden of the attorney fees and costs anyway. But at least from a preliminary standpoint, Irv, I think it's a good idea to explore. And again, I don't want to cast this the wrong way. There are many municipalities who recognize, hey, these people in associations are the bulk of the people who live in this township or us or a municipality. We want to help them. We're all on the same team here. In fact, half of our township committee board lives in an association, right? So let's do the right thing. So again, I'm not trying to disparage municipalities, but the interests are not 100% aligned. Does the act cover leaf removal and reimbursement? Yes. Yes, did I mention that? I think I did. Trash, waste, leaves, yes, leaves and recycling. Yep. So, yep,
But, right, Fran, the township has to offer that to the rest of the residents though, right? Like similarly situated. I
that's
believe there's
correct.
some,
That's correct. It has to,
yeah.
that's right. Mike is emphasizing a point I made earlier, which is if they don't do it on the public roads, guess what? You don't get it, right? Because that whole argument goes away. So again, we talked about trash. This happens a lot. So in my town, the township does not pay for trash removal on the public streets. Everybody in my town has to go out and hire their own trash removal person. Now we have associations in our town as well. Now those associations can't point to the Municipal Services Act and say, "Hey, wait a second, town. Municipal Services Act says you got to pay for trash," because the town would say, "No, we don't, because we don't provide that on the public streets." You see what I'm saying? So that's a good. It's good that you highlighted that, Mike, again, because it's what the township would provide on the what the township is providing on the public streets, and reimbursement at the cost of the township, not at the cost of the association.
And just another comment on the leaf removal. I know a lot of townships will require that everybody push their leaves right to the curb and then they sit there for a couple weeks and then they'll come by and suck it all up with their big vacuum cleaner thing. A lot of communities just don't want to do that, and a lot of towns will offer that to them in lieu of reimbursing them, but usually they don't want a bunch of leaves sitting outside. So, leaf removal doesn't become typically not a big issue in my experience.
Yep. Randy says, what's the status of municipal reimbursement, including fire hydrants? And that's like the standing water charge. I don't want to give you wrong information, Randy. I have not looked at that. I started to look at it this morning. I just didn't get to it. So I don't want to give you the wrong information, but the last time I looked at it was several years ago and it was not being included in the Municipal Services Act. But again, don't quote me on that. I would have to do an update on that. Go ahead, Mike.
I asked for the formula of the factoring of reimbursement, so that's correct. That's the right thing to do. And then, by the way, if you do not have an agreement with your town, and Fran may have touched on this earlier, you should talk to your attorney and negotiate the agreement with the town, the township municipal reimbursement agreement. You'd be surprised, a lot of communities out there just do not have one. So they're just going with whatever formula the township says that they are using, which oftentimes can be shorting the association.
Okay. Dave Gorham says, yes. I'm sorry, Dave. I don't know what you're saying yes to. So if you could tell us that, that would be awesome. Thanks, Dave. Fred says, we have run into townships that say the budget has already been closed and could not go back even 2 years. We couldn't possibly pay you, right? We couldn't possibly pay you. So our argument always is, yes, you can actually, you can pay us. I'm in the middle of an issue right now with an engineering firm where the engineer did a great job and the association has not paid the engineer. And they said, well, it's not in the budget this year, so we're not paying. It's like, no, that's not how it works, actually. If you use services, if you have an obligation, whether it's statutory or contractual, you got to pay. You got to pay. The however, Fred, that's part of the nuanced timing issue. So in terms of if you have to bring a claim, when do you have to bring a claim? So that would have to be looked at carefully with respect to each claim, each case, each budgetary year, et cetera, and what the township did, because you don't want to back into a Wyckoff's Mill case where the court says you didn't act fast enough, and they imposed a 45-day restriction because the township there actually passed a resolution and cut a check. Um, what do you do if you have an agreement and the town does not send the summary sheet or the checks 2 years now? So again, Judy, that's again cost benefit, and you got to sue. You got to sue to bring a claim, right? And again, it's cost benefit. Um, so again, you got to be careful though on the timing. Oh, Dave says, Raving Fran here, David Merritt handled this exact topic for us with a municipality recently. We did a cost benefit analysis to decide to move forward, resulting in them paying the 2024 billing. It was not a lawsuit, but really just McGovern pushing professionally. Worked brilliantly. So thanks, Dave. Really appreciate that. You do have to be cautious though, right? So I appreciate Dave's comments. That's great. And we have been successful in a number of just negotiation sessions and a number of lawsuits. But I have to say, we were very disappointed in the lawsuit we had 2 years ago where we were unsuccessful at the trial court level, and we couldn't get it up to the appellate division. The association just cut their losses. Uh, so again, you just have to be cautious. You have to talk to the professionals, talk to your accountants, talk to the lawyers about where you go, and for sure, try and negotiate a settlement. Go ahead, Mike.
Hi, Fran. I'm currently working on a new community, but unfortunately, the previous management did not process the reimbursement, and we have not been able to retrieve any of the prior invoices. Would it be possible to use invoices from other years as a reference in this case? Before I turn over to Fran, I'd say it's, in my experience, it's unlikely the township is going to permit you to do that and to rely on that for reimbursement. You might have to really push those vendors, but I don't know if you have any other thoughts, Fran.
Yeah, I mean, I think, Jasmine, you get what you can. Well, first of all, if it's a brand new community and they don't have counsel yet, I know this guy who does a lot of community association law, and we'll be happy to send your proposal. So we appreciate you attending. But in terms of the documentation, um, I would get, as Mike said, get what you can. If you have to track it back to the vendors, track it back. It's all going to just be a matter of proofs. And I should have mentioned this before. The statute itself requires documentation, right? So even though it says the township is only obligated to pay what it would have cost the township to do the work, the association still has to provide proof of what it expended for the work. The reason for that is there are very rare instances where um, the association spent less than the township would have spent. You see what I'm saying? So, and the association can't get a windfall. You see what I'm saying? The association can't get a profit over what it spent. So that's why the township requires the documentation. And Jasmine raises a really kind of knotty issue in terms of getting the documentation and substantiating the prior expenses, because substantiating the prior expenses is a requirement under the Act. Al's back. Our street lighting cost is a bulk rate currently at $64.50 a month, and there's a rate increase that went into effect. So Al, the question is on the $64.50 a month street lighting charge. You really have to, and this is so annoying, right? But you really have to get into your street lighting charges, because again, you're only going to get reimbursed, generally speaking. Some municipalities give you a little more, but you're only going to get reimbursed on your electricity charges. And if you do a deep dive, and I know Al, you're into the industry sort of, the invoices will break down sometimes the cost of electricity. I think all the time, actually, the cost of electricity, the amortization of the equipment, right? So they'll actually break out the charge in the utility bills that show the cost of the equipment. And the municipality will latch on to that and say, okay, well, that's nice that you're paying $64.50 a month, but only 2,500 of that is electricity. The rest of it is amortization of equipment, wiring, light bulbs, maintenance, et cetera. So you really got to kind of, it's annoying, but you really kind of got to get granular with those invoices. Would paving of the main roads be part of the act? No. Who or what department do we contact the municipality to get this information? So, Terry, that's a good question. So, The paving is not, right? So the paving is not part of the Municipal Services Act, unfortunately. As Al said before, there's a pretty good argument that it should be, but it didn't work out that way in the compromise for the act. Who do you get in touch with at the township? Our general starting point is from the association side of things before you even get the lawyers involved. Hey, township administrator. Hey, township administrator, can you talk to us, explain what our policy is, send over your form, municipal services reimbursement agreement. Um, Most every municipality we work with now at least has a form municipal services agreement, but don't buy into the argument. Well, golly, this is the form that we use, right? Therefore, we're bound by it. This is the formula we use, therefore, we're bound by it. That doesn't mean, right, if they use a form, you're bound by it. A particular formula doesn't mean you're bound by it, but it's a good starting point. So township administrator, and then for our world, the lawyer's world, we wind up talking to the township attorney, right? And sometimes we deal directly with the township administrator as well, but it's generally the township administrator. Um, in that case that I mentioned before, Wyckoff's Mill, the when the trial court said no, 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 you're bound, you're cut off by this 45-day limit because the township did the resolution. One of the board members, I think she was the board president, went to the township committee hearing the following month and complained about how the township was not treating them properly, et cetera, et cetera. And the court noted that and basically said, we don't care, right? So if doing things doesn't count if you're going to be bound by a legal concept, right? So in the Wyckoff's Mill case, there was a lot of discussion. The board president even appeared at a township committee meeting. But the resolution was passed anyway, and they kept talking. They kept negotiating, kept talking, and Wyckoff's Mill raised the argument, well, wait a second. We were kind of deceived in letting this 45 days pass because you guys were still talking about us as a possible consensual resolution. And the court said, we don't care. We don't care. The fact that they were talking to you doesn't preserve your claims. So you got it's like I said, it's very nuanced. Um, but that was a good question, Terry. Louise Schwartz. Is it legal to request a criminal background check for potential renters? Can also association request a particular criminal background check? So, Louise, this is really fraught with risk, criminal background checks. So, generally speaking, you have to treat people similarly situated in a similar fashion. So, what happens with criminal background checks is oftentimes the question comes up, well, do you do criminal background checks on your owner occupants? Right? And the answer is no. Right? So how do I know that Bob the owner is not a pedophile and Kenny the renter is not a pedophile? You wouldn't know, right? So, but basically speaking, you want to treat the law strongly suggests, requires, in fact, that owner occupants are treated in similar fashion vis-a-vis the association um, as investor owners. So things get even again a little more nuanced here, and this is where again I don't want to be giving a legal opinion to anyone. It's just a conversation. There are associations, right, that have rental lease riders that may require the owner to get it from their uh, potential tenant. Um, and I don't know, again, as I sit here, I don't want to give you bad advice. I don't know how enforceable that is. So the criminal background checks are very dicey right now. So I'd be careful about that. But Louise goes on to say, can also association request a particular criminal background check? So I think the answer on that is a definite maybe, right? And that's a lawyer answer. And I'll give you the case that I had. We had a gentleman who moved into one of our communities who was accused of being a pedophile. Um, and of course, it was not, it was not an age-restricted community. There were children in the community, and that's not cool, right? We don't like that. We have to deal with it. We didn't know if this person was just falsely accused. Is it just part of the rumor mill? Is it a tier two offender, a tier three offender, which makes a big difference in terms of violations against children, violations that involve violence, et cetera, et cetera. There's a whole tier system in the sexual predator type law area. What we did there, though, was on our own, without getting permission from him, we were able to find, we didn't do anything nefarious, but we were able to find that he had not been convicted as a pedophile. However, he had been charged in Florida, right? So he had been charged in Florida. So we were in the middle, and this is way off topic, and we should probably do another seminar on this. But we were in the middle of trying to figure out how we're going to deal with this guy because he was living there and he had been charged with a pedophile claim in Florida, different association. The good news was he was convicted and locked up in Florida before we had to resolve the issue. So it worked out there. But criminal background checks, you really have to have your particular facts come to us or come whoever your attorney is, and we'll work through them. Would Rove paving be municipal? No, it would not. Paul Masella. What would you recommend if the town is doing a lot for the HOA that they are not formally obligated to do? And when you went to them to formalize it, you got the impression that doing so might result in them no longer providing the services. So they're doing for a lot of us that they should legally have to do. So I don't want to take the chance of blowing that arrangement, but I agree with you that this should be formalized. Are there any other risks that I am not considering for just letting the current status quo? So Paul, that's an awesome question. So if you have a municipality that's going well over and above, I would hesitate before I started opening up a can of worms and saying like, we really need a written agreement on this. You're like, it sounds like you got a win in the pocket, right? So I think you take that win if they're going over and above their legal obligations and say, thank you so much. We appreciate the fact that you appreciate us and are trying to treat us as fairly as possible, right? Because if they're going over and above anyway right now, what would your contract get you more? Nothing, right? So it sounds like that's all downside. Sounds like that would be all downside if they're fully reimbursing you or for fully performing the work and actually going over and above right now. So yeah, I would think twice before I do that. But again, speak to your own attorney. Uh, and should these agreements be for each service or as one comprehensive document? Where should these documents be maintained? So it's my experience has been a municipal service agreement addresses all of these services, right? So it's comprehensive, and there's a copy kept with the township attorney. There's a copy contact kept with the township administrator. Often the director of public works has a copy, and the association's management office has a copy. Stormwater management system, the township and the county both drain into our system, into our catch basin. Yeah, Deb, that's an argument, but it's not addressed in the Municipal Services Act in terms of stormwater. Elise says, with a builder control board, how would a homeowner know if they are reimbursing the community for these municipal services? So Elise, good question. You just asked the board, and your manager would have the budget and also the financial statement. So generally, an association with municipal services agreement would have a line item, for municipal services revenue. So that tips off most people. The tough transition cases. So as you probably know, we do a lot of transition cases coming from homeowners from a developer control board, transitioning to a homeowner control board. And the cases where we've had the biggest issue is even where the developer agreement does not require the developer to provide those services, the developer does it anyway, but doesn't put the cost of those services in the pro forma budget that is in the POS. So what happens is during the developer control period, the developer is dealing with trash, the developer is dealing with snow removal, the developer is dealing with street lighting bills, but it's off the books. Then the homeowners take over the board and they go, wow, why did our budget go up by 30% or whatever? And it becomes honestly, it becomes a misrepresentation case for us on behalf of the association because the developer, although he'll be very indignant, he'll be saying, I did you a favor. I did you a favor for paying all this for 3 years. And now you're coming back at me saying you misrepresented to our homeowners the actual cost of operating this association. And we're saying, yeah, because you put a pro forma budget in the public offering statement that didn't include normal, ordinary operating expenses, right? You misled our people to what a real cost of living here would be. Now you got to do something to make it right. Okay, so again, that's a nuanced issue, and you really need to look at your budget too in the public offering statement. Manchester Township has 19 adult plus 55 plus, oh, 19 plus, okay. The township has a location citizens drop off their grass, strip clippings and leave. 2 years ago, they refused lawn mowing companies to drop there. All citizens can drop there, but not these lawn mowing companies who are servicing. This does seem wrong and unfair, Bill. So basically, it seems like what happened is for years, Manchester Township said, hey, you can drop your clippings here. And then they said, no, 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 you can't anymore if it's with a commercial landscaper. This is just meant for homeowners themselves. Um, that is not covered in the act, right? But what you may want to look into is a political solution to that. Because as you don't need me to tell you that Manchester is dominated by 55 and older communities in terms of population. Uh, and I think they should do the right thing too. That being said, the Act, the Municipal Services Act, is not fair. And we all know this. We all lived long enough. The life is not fair. So, of course, Municipal Services Act was passed. Who were the first people to want to say, me too, me too, me too? The apartment owners, right? The apartment owners. So, well, wait a second. We have residential housing. We own the residential housing. Our tenants are paying us. We're paying the taxes, but we pay the taxes out of our tenants' rent. Shouldn't we, as apartment building owners or apartment complex owners, also get the benefit of the Municipal Services Act? And I think this was kind of a stretch, but the court just didn't want to go there. They wanted to leave it to the legislature, I think. The court said, no, 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 no. We're not going to do that. We're not going to stretch the act to cover apartments. They're commercial, number one. And number two, the act addressing homeowners association, condo associations had a reasonable basis. And the reasonable basis was to encourage home ownership rather than tenancy. Now, I think that's a bit of a stretch. I think there's some, mental gymnastics that went into that, but the answer is basically it doesn't cover everything. But for the Manchester Township case, if I was Manchester Township, I might think about, hey, issuing dumping permits or licenses to these commercial vendors. It sounds to me though you're contrasting it with the individuals who cut their grass. Um, if the vendor is an association vendor, right, and they are entitled to certain things, it really wouldn't impact what's going on within the association, right? Because cutting your grass is not covered. You see what I'm saying? Cutting your grass is not covered anyway. Um, Dave says, sue people. I appreciate you, Dave. Footnote, lawn mowing company raised their fees 50% to cover the time and expenses to haul to the township. Right. So, but grass clipping is not covered in the Municipal Services Act. That again goes back to an equal protection type argument under the state and federal constitution, which has not been a winner in this realm. Joe Rosenberg says, hey, Joe, by the way, I didn't see you. You need to first give a conditional approval and then have the tenant authorization to run the criminal check. Right. So Joe is highlighting something that to get a criminal background check, and we do this with our employees, right? I can't just go out and get a criminal background check on Joe, right? Joe would have to sign a certain form. I'd say, hey, Joe, you look like a trustworthy guy, but this is part of our process. Please sign off and agree to do this. And you would do it. So it's a multi-step thing. It gets a little naughty in certain situation. It gets very naughty in the employment interview process. There are certain times when you can ask about criminal background checks. You can ask about criminal history. You can ask about even arrest history as opposed to criminal conviction history. So it's a very nuanced subject as well. And maybe we should do a First Friday with Fran just on background checks. But I will keep that in mind. Does anybody have anything else? Wow, we went over to 106. That was 36 minutes. But they were all really, really good questions, and they highlighted things that I probably should have highlighted in my initial presentation. So I always rely on all of you to help me cover as much of the material as possible. And always feel free to, if there's a hot topic that you want to talk about, shoot me an email, and we'll consider it for a First Friday with Fran topic. That being said, it's great to see everybody. Have a super June, and we'll see you, I guess, around the 4th of July, around that time. All right, so have fun.